I hear more bodies. Yes,
Oh, we got another chair in front there.
oh my. There's two up here, gentlemen. Well, I don't know about everybody else, but it was a good Christmas.
For sure.
Yeah,
Kevin's family should be very, very happy that he's okay.
Well, it's 6 o'clock, so I'll call this special meeting of the Sturgis Common Council to order. First item is approval of the agenda.
So moved.
We got a first by Mike and a second by Becca. All those in favor of the agenda, please indicate by stating yes.
Yes.
Opposed to no. Next item is Pledge of Allegiance. Please stand and remove cover and let's do the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Get you on the floor, sis. Item 4 is consideration of the petition on the change of form of government. Mr. Marshall has our staff report here, so at this point in time, I'll just turn it over to you, Mr. Marshall.
Thank you, Mr. Mayor and members of the Common Council. I have prepared a city attorney's report that's on the screen right now, and I will direct your attention to the executive summary. Points 2 and 3 on the executive summary are more appropriate for an initial discussion at an executive session because they discuss matters in contemplation of litigation. So I'll confine my remarks to item number 1. I had been asked by the city finance officer and by the mayor to render an opinion on the legality of the petition that has been circulated. It's my opinion that the question posed in the petition is invalid and that there have been no valid signatures submitted for verification because of the invalidity of the question. I believe the question is invalid because it mixes the concepts of form of government and the role of city manager. South Dakota law recognizes two forms of city government, the aldermanic form and the commissioner form. South Dakota law also grants to the city council the authority to employ a city manager under either form of government. So the petition, styled as a petition to change the form of government, is, in my opinion, invalid. The answer is really quite short. The rest of the reasons are set forth in the discussion called the propriety of the question presented. And highlighting that is the idea that you as council members enjoy only the powers that are expressly granted to you by state law. State law does not grant you the power to employ a city manager. Instead, that is a special power that only arises upon the vote of the citizens of your municipality. After a city manager has been appointed, and they can be a city manager can be appointed for either form of government, state law provides the manner in which the city manager can be removed for office. That procedure affords the city manager significant due process protections that are not available in the petition as presented, and indeed really could not be, because they are the rights of the city manager. So, to me, it's really become a very simple issue when you look at the underlying question, and that is the question proper? It's my opinion the question is not proper because it improperly mixes the idea of the office and the officer. And with that, I'd be happy to entertain any questions the council may have.
I want a little clarity. Once there's an election, which the city council went through, or the city of Sturgis went through in 2008, I believe was the year that the city manager was changed to city manager. But after that, it's the city council who employs and decides. If you said city manager at the end, and I just want for clarity that it's the city council.
Yes, thank you, Mr. Mayor. It is the city council who determines whether a city manager can be discharged. And that process, I might add, affords the city manager a right of appeal, which is not present in an initiated measure.
So in this process, and I guess for the necessity of this meeting, if these irregularities were not found or the challenge of the question was not present, the finance officer would turn over the petitions to the city council. It is your recommendation for that there's not a valid petition to turn over to the city council.
That is correct, Mr. Mayor.
How about questions, discussion from council at this point in time? Go ahead, Kevin.
Yes, I'd like to make a statement that as a counselor, I took an oath of office, same oath that the rest of us all took, to uphold the Constitution of the United States, Constitution of the state of South Dakota, our state laws, and our city ordinances. Our city ordinance, our city attorney who represents the council is raising concerns that must be answered prior to setting this election. And I feel the oath compels us to have the city attorney's concern answered by a third party. These petitions signed by our residents indicate there is a problem with city government that we can't ignore. Me personally, I think the city manager has done an excellent job on 80% of his job. 20% not as excellent, but that's not his fault. That's the council's fault, and we need to be better leaders as counselors. I mean, no disrespect to the current or past councils. No matter what form of government our city has, these questions are going to arise. These items will still be an issue, and we need to start working on them more diligently today. Communications, transparency, accuracy, more guidance from the council are the rock that we need to build off of to build back trust with our community. And we can, no matter where this goes today and tonight, we can start that now and continue. I mean, we've been working on these sort of things, but I think we need to swing a bigger stick. Thank you.
Thanks, Kevin. Anybody else on council have? Go ahead,
I would
Dave.
concur with Kevin. I agree with everything that he had to say. And also, looking at things, I like the way this is set up by Mr. Marshall, because actually we're going to have a third party. Am I correct on that?
Whether that happens is a question entirely up to you as members of the council.
All right.
You have that option available.
So Dave, is your question there in having a third party in terms of confirming what Mark is saying about it being an improper question?
Yes.
Okay.
I feel that is the way we should go, and that's what's necessary.
there have been other issues with the petitions. So are we going to engage counsel above Mr. Marshall at the state level for the improprieties on the petitions?
If I may, Mr. Mayor?
Go ahead, Mark.
That is certainly a valid question, Mr. Bichon. Whether the council chooses to go in that direction, I believe is best addressed during executive session. Nothing you're doing right here and now limits your ability to do so if you choose.
Thank you.
I kind of look at this like a couple of dominoes here. I don't know if we need to address the second domino until we get the first one. And I think determining, if it's a proper question or not is the thing we really need to get to.
And in front of that, Aaron, the fact that there isn't actually a petition to submit right now, which would be answered with what you're stating.
Correct. Because I've read through, with the report that Mark sent out, and I appreciate that, Mark. And then reading through the state codified law and looking at some of the municipality stuff, I'm still unclear. If you have a petition by the people, and I don't know, I haven't read the whole codified law for South Dakota, but my assumption is that it's when you have a petition, any issue that you bring up in petition may not necessarily be clarified as that's an option, an approach to take within the state codified law. So I'm not saying it's wrong. I just do agree, Dave, I think we need to have that question answered.
Any other council discussion at this point in time?
Mr. Mayor, my name is Kellen Millard. I'm an attorney and I represent a couple of the petitions. I'd like to address the council if I could.
You bet. I wanted to do one more thing here before we open up to the public, but Mr. Willard, we'll get there for sure. So I want to look for clarity and direction for the legal aspect, and mostly clarity because I think it's been presented already, Mr. Marshall. But no action needed by the council on item 4 because of our view of an invalid petition submission.
That is correct, Mr. Mayor.
Can any other additional comments to help clarify with that? Or is it just the mere fact that what's stated in the council report is?
Well, if I may.
Please.
To approach it in another way, it's the old analogy about the cart and the horse. Here, the cart is the petition, and unless the cart is sound, you can't have a horse pulling it around or it won't go anywhere. So my recommendation to you is, let's see if the cart is appropriate, and if appropriate, we can schedule an election at that time.
Other discussion from council. Mr. Willard, I'd have you come up to the microphone so it can be caught for the stream and for the record.
Do you mind if I stand?
Nope. Yep, go ahead. Should pick your voice up.
Thank you, Mr. Mayor. As I indicated, I represent Tammy and Justin Bond as well as Brenda Vasconetz, a couple of the petitioners in this matter. First thing that I'd like to just address is the state voters just voted on recreational use of marijuana law, right? And then that was challenged after the fact, and then it was found unconstitutional. The job that the finance office has in this situation that you have is ministerial, and I'll get into that here in a little bit, but as we all know, here in South Dakota, under God the people rule, and we have the right to petition our government, right? First Amendment, the U.S. Constitution, as well as provided for in our state constitution. What's not included in the report, and I like your city attorney, don't get me wrong, but what's not included is SDCL 2-1-11. That's a statute that applies to all petitions, and it says, quote, "They shall be liberally construed so that the real intention of the petitioners may not be defeated by a mere technicality," end quote. When this petition was filed, the ministerial duty of the finance office was to look at the matters apparent on the face of the petition. And again, it's strictly ministerial. There's no authority in state law that authorizes the finance office to exercise any discretion in whether or not to do certain things, right? Everything's spelled out. The finance office is not acting in a judicial or a quasi-judicial capacity. There's no authority to conduct an investigation as was done and indicated in this memorandum. There's no authority to call signers of the petition and interrogate them. One would wonder, if we have a government investigation, were those people provided with their statutory and constitutional rights, such as the right to remain silent when being interrogated by a government officer?
I'm going to interrupt you and suggest that the reference to the right against self-incrimination doesn't apply to people who are asked if someone witnessed their signature. There's no indication of any illegality on behalf of the signers.
Okay, and the council can do what they want with that objection. The duty of the finance officer is to declare the petition valid or invalid. That hasn't been done yet. That hasn't been done. The duty of the finance officer is to tell us how many signatures are necessary to get to the 15% threshold that we have, how many total votes were received, and how many were rejected or stricken for being invalid. The memorandum talks about people apparently calling and requesting their names being stricken, and some other just complete hearsay evidence. Again, we have not been informed whether or not the petition has been declared valid or invalid by the finance officer. SDCL 12-1-15 says that the petitions do not become public until that happens. This city put those petitions on the website. That was done. There's been no declaration whether it's valid or invalid. And I'll tell you why we know that, because to declare it invalid, there has to be notice given to the petitioners. That hasn't been done. The basic concept of due process in our nation is notice and opportunity to be heard. Neither of those things were provided to the petitioners here. If I could just address some of the things in the memo that's on the screen here. Item number 1 says the finance officer should not schedule an election. Well, the finance officer should never schedule an election. They declare whether it's valid or invalid. You as a body schedule the election. So again, I ask, are the petitions being filed or not? And if they are not being filed, why haven't my clients been provided with notice pursuant to statute? The propriety of the question. Nothing requires the petition to include the relevant statute. Here, what was included was SDCL 9-11-6 and, quote, other applicable law, end quote. Again, 2-1-11 as well as SDCL 9-20-10 say that you are to liberally construe these petitions. And it's for good reason. Why should a petition be denied because of the subjective opinions of bureaucrats? In terms of a declaratory action, I don't think the council even needs to consider that, because if you don't schedule the election, we'll be pursuing a writ of mandamus, and then the courts can figure it out from there. And I think we can probably work together on stipulated facts to make it happen pretty quick. The irregularities that are mentioned in the memo. First off, the memo cites a bunch of criminal statutes. It doesn't cite any other authority to say why the petitions can be denied or refuse to set the election. One of the first things it says was irregular, that 10 instances, or they had 10 instances of duplicate signatures. That's not irregular. That happens. That's why it's provided for in the administrative rules that say the first signature presented is valid if there's multiple ones. It's provided for. That happens. That's why it's there. Another thing brought up is that it, quote, contained one forged signature, end quote. There's no proof of that. There's been no adjudication of that, and there's no authority to reject all of the signatures because of that. There simply is no authority for that, or to deny the election. It's a conclusive statement when all that's due here, the only duty is the ministerial act of verifying the petitions pursuant to the rules. We have administrative rules that lay out what was supposed to be done. It wasn't done here. The next thing is that the finance office received reports that the petition was left unattended. That's triple hearsay. That somebody told the finance officer this, the finance officer told the attorney this, and the attorney's now telling you that. It wouldn't even be admissible in a court of law, much less when there's no authority to deny the voters their petition and their right to an election here. The next thing is, as an irregularity, that there was different handwriting for the county and the date. There's no authority saying it has to be in the handwriting of the signer. In fact, the authority says the exact opposite. SDCL 9-13-11 says each voter or the person circulating shall add the address and date. That's provided for. There's nothing wrong about that. You can't use that to deny the petition in the election. Also, Administrative Rule 5020800 sub 7 also says the circulator can add missing info on the signature lines. That's after it's been filed with the finance office. There's nothing wrong about the handwriting being different, nor should there be. We should be worried about the idea that a bureaucrat can have an opinion that handwriting is different to defeat a petition and not have the election. The next thing is that 2 dates were obviously altered. Again, there's no adjudication of that, and there's no authority to deny all the other signatures because of that. If you want to deny those 2 signatures, let's talk about it. Same with the, allegation that 89 people were not registered and 9 were not in the city limits. All that happens there is pursuant to SDCL 2-1-14, those votes or signatures are not counted. So the question that this council should be asking is, how many votes were received in those petitions? How many does the finance officer think are invalid for whatever reason? And then how many are required for that 15% threshold? Where are we at then? Are there enough signatures? The petition is very clear. It says basically to change from an aldermanic form of government with a city manager to an aldermanic without city manager. That's pretty clear, folks. And again, you're supposed to liberally construe that. My last comment on the memo is the statements about Ms. Bosworth in that Supreme Court case. My recollection is in that case there was 6 petitions, a 1-page front back, that Ms. Bosworth signed knowing that she didn't circulate those petitions. But what's important to note is that in that case, the Secretary of State said the petition was valid, and Ms. Bosworth was on the ballot, and then this investigation, all of that is totally separate, because your job is not to investigate these things. You guys are not criminal investigators. You're not law enforcement. That's not your job. Essentially, what I'm asking the council to do here is hold your employees accountable. Ask them those things that I talked about. How many votes were there? Which ones are invalid and why? How many votes are needed for the 15% threshold? Another comment I just want to address, a discussion that happened earlier, is the petition is not seeking to remove the city manager. There is a statutory scheme for the council to remove the city manager. This petition clearly says we are removing the city manager position, right? We're not going to hire a city manager down the road. We're removing that petition. There's a whole statutory chapter on it, and you should follow it. So I thank you for the time, Mr. Mayor, and I would just ask that you, as a body, ask these questions and follow the law. Liberally construe the statute, and whether or not the election needs to be handled under the change of form of government or the city manager petition form, do that. Do one of those. Thank you.
At this point, does council have anything to add, or Dave, you're reaching for the microphone?
I've got a couple questions, and I would just like to have things clarified, and I think Mr. Marshall could go and answer that. My opinion at the present time, and maybe I'm way off on this, I don't think that this petition has actually been declared either valid or invalid at the present time. Am I correct on that?
No. There has been no verification signed by the city finance officer to submit the petition.
Okay, so I will ask the question about how many votes are needed to reach that 15%. I mean, it was brought up, and so I think that would be fine to.
My understanding is 700
All right.
signatures are required.
How many signatures were submitted?
Total signatures were 758.
Okay. And we really don't know for sure at the present time how many are valid?
That is correct.
All right.
You know, I still think the first question that we discussed about being a valid answer, or question or not, needs to be answered. I mean, I understand where both the lawyers are coming from. I'm not sure exactly what the right answer is. I lean towards that a valid petition has the right to question anything in some sense. I think that's my gut, but my gut's not law either. But I would like to be able to answer that question. When it comes down to the petitions, I think that's secondary, and to determine what that would be. I guess to answer, one of the assertions that the council would investigate. That's, as I understand, I'm just one of many here, but I don't think it was ever our intent to investigate. Our intent was if there was questions there in terms of having sufficient valid signatures or improprietary issues that came up on that, was to turn that over to somebody else to make, to investigate and make that determination and provide that feedback, back to the council.
I agree with that completely.
So who can ask that first question? Who answered that? What is the process for that?
That is a question that I've suggested should be asked during executive session, where you can discuss the litigation avenues available to you.
No, I'm talking about the first, about
The declaratory.
can this petition go forward? Is it a proper question? I mean, we can talk about that in executive, but I'm not sure if we're going to get the right answer because we only have,
You can ask that question in executive session and pose it to a higher body, either the election board or circuit court.
Okay. All right.
I guess, where are we at time-wise on having to deal with this petition?
It has not been verified, so the timeline, in my opinion, hasn't started running.
Okay, it's not like from the date that they submit it, we have so much time to...
Not with the question that's been raised. From the date that has been submitted assumes a valid form of question.
And if some decision has come up that it is a valid form of question, then it would be within 15 days of that date. Am I correct?
Yes.
Just last comment here. I'm not just addressing the council, but the community also. There's obviously a lot of emotion that's tied, to this petition and this question on both sides. Sitting, being a member of the community for a long time, I've had these discussions with people long before I ever became on council. I've had people give me feedback while I've been on council. There are people for and against. Regardless of what that outcome is, I think, exercising some patience here to make sure that this is a proper question. And if it is, then we'll move forward. In terms of having an election sooner than later, I'm not sure what that serves. Again, we're trying to, build relations and, build bridges in this community, not, tear things down. And again, even though this is an emotional topic, I think if we take it slower, answer all the questions, make sure things are valid, do this in just lawful way, and then when it's all said and done, if we do go forward with this, then we'll let the people speak and the answer's done. But does it matter if it happens in February or if it happens, 6 months from now? If there is a strong desire from the community to change from not having a city manager, just going back to what we had before in 2008, just mayoral and council, I think that if that's the outcome, again, I think it's not a bad thing to take the time, to get there, if that's the case. So again, I would just exercise, for us, I'd exercise some patience. Let's answer the question. Mark has given us, a couple of bodies that would provide some insight on what that would be. And then once we get those answers, then I guess we'll determine where we go from there.
Mr. Mayor? Okay. I would just like to say that I concur with Councilman Jordan. I think his keyword in his words is patience. And I believe that that is what we all need to have. I'd also like to add 2 more words, and that's due diligence. As a council member, my responsibility is to move forward with what is in the best interest for our community. And I believe that the report presented by our city attorney is a first step in that. And I think that we need to do our due diligence in ensuring that the election concerning this petition would be valid, would be legal. And I think that most of our citizens would want to ensure that that is the path that we're on. So I think that, again, patience and due diligence is what is being asked for in this situation.
Anything else from council? I guess to reiterate, at this point in time, on item 4, there truly is no council action that needs to occur or a vote that needs to occur. I think it's pertinent to reiterate the fact that we're still moving forward and there's a plan to take it to a third party with better understanding than what we have at this point and go from there. I do believe it's necessary for council to have an executive session at some point in time to talk about that. Since we're here tonight, it makes sense tonight. I don't think it makes sense. I think that Aaron, in his discussion, he made it a good point where the fact that at this point in time on this particular item, I don't think it's the time to open it up for public discussion as far as what the different feelings are from each side. I think the step one is to, from what Mr. Willard said, either there's going to be a filing on his side with circuit court or our consideration for future steps for the city to take through the court systems, which can be considered and for future actions can occur. So there's no further council discussion on item 4. Go ahead, Aaron.
Waiting to get some response, I'm good with that. But I would tell you, talking with the community is that even though we're not necessarily going to have a discussion here right now, I'm obviously interested in hear what people, and all of us are, and what people, their thoughts are on having a city manager or not having a city manager. And the reason I ask that question is that, in having discussions over the years, there's always been so much emotion tied to this question. Sometimes it's been difficult for me from a logic perspective to understand really what the issue is. And so I think this is an opportunity to have that discussion, between myself, you, and the rest of the counselors, and kind of educate us on where you're coming from, what those issues are, what are the problems, and why is this the solution, either for or against. That would help us as we kind of think about, this difficult question and trying to determine, what's best for our community. Because ultimately, whatever those answers are, it kind of goes back to what Kevin said at the beginning. I mean, we as a council can probably address many of those questions, you know, as things stand right now in our city government, how we're structured. So again, having an understanding what those issues are, I think would be beneficial for us, because again, this is not going away anytime soon. And I'm kind of looking at it as an opportunity to have some good discussions, kind of determine, you know, where we're at, where people think we should be, and maybe how we get there.
Thanks, Aaron. Anything else from council? Go ahead, Becca.
Sure. Well, I think, too, it needs to be said that by us taking a moment to pause to have these questions looked at and answered is in no way to be construed as thwarting the will of the people, or that we are trying to impose any kind of our own personal opinions or will. I just want to ensure that that is stated.
With no further discussion at this point, and the recommendation of no action from the council, brings us to any other business, which I think does include executive session, but I would open up a non-agenda item discussion for a brief moment in time if anyone has the desire to do so from the public. Council have anything to add? Is there a motion for executive session?
So moved.
Got a first by Dave, second by Becca. We'll go into executive session at 6:35. We'll go in at 6:40 or so. So appreciate everybody coming out, and we'll continue to plug along and follow the process as we go. Thank you.